start the. And I'd like to introduce Adam Carlson. Adam?
Hi, everyone. I'm Adam Carlson, one of the managing partners at Casper, Meadows, Schwartz, and Cook, personal injury firm in Walnut Creek. And if you're here, then you're probably interested in some of the other presentations that have gone on and are going on as a part of the series. As Ann mentioned, this series has been put together by the litigation section, but also by help from the barristers and young lawyers section. A lot of people, not just myself, especially Ann, have been working hard to put this all together. We came up with some interesting topics for litigators dealing with trial issues. So I'm going to go over what these programs were. The ones that have happened in the past, you may be interested in. And Ann, is it correct that they're on demand?
Right now, they are on our self-study webpage. You can watch them just if you'd like to watch them. If you'd like credit for them, or you know someone who wants to watch them and like self-study credit for them, you can watch them. There's a form to fill out and send it to us, and we'll make sure you get the credit. So they're at CCCBA.org, and you can just type in self-study, and I think it'll take you to the self-study page.
Thank you. Yeah, so you may want to seek these. If you're here today, you're probably interested in the other topics that we've had. The first one was developing the theory of the case. That was put on at the MCLE Spectacular. On January 11th, we had discovery and depositions, the meat and potatoes of trial preparation. Last month in February, we had what do you want and how do you get it? Framing issues and drafting pleadings. Today, you're going to be seeing a presentation on addressing the jury and jury selection and opening closing. Next month in April, we have L. Wood says, I object, direct and cross-examination on April 12th. May 10th, we have mediation, what, why, when, and how. June 7th, we're going to have creating trial presentations, everything you didn't know you needed to know. And you should definitely attend that one. That has one of the best speakers of all time by the name of Adam Carlson. And we are also going to be putting on one in July. This had not been previously announced. We'll get out some information about when this will be, probably like these other ones, the first or second Tuesday of the month at about 4:30. And that will be dealing with representing a client with concurrent criminal cases. So hopefully you'll attend those other programs. If you want to seek out the other ones, take a look. As Ann mentioned, you can always reach out to her on how to find it. And I'm going to introduce the moderator for today, my law partner, Nick Casper. And fun fact about Nick Casper, I don't know if he wants me to share this, but he was on The Price is Right, and he won a lot of items. He did really well, except when it came to the Showcase Showdown, where he kind of missed it. But anyway, fun fact about Nick Casper, he's very smart, an incredible partner to have with my journeys in personal injury law. So Nick, please take it away.
Thanks, Adam. Yeah, I really appreciate you sharing my successes and failures. One could say I failed at the closing argument of my Price is Right appearance. But I'm also going to be presenting today on opening statement, just to give you all kind of a roadmap. These are a brief survey of these topics: jury selection, opening statement, closing argument. Those are all deserving of a multiple hour, maybe even a full day presentation. They are very fertile areas, but we intend to just give an overview and some real kind of practical kind of do's and don'ts, guidelines, et cetera, on these topics. In terms of the presenters, in addition to myself, there is Patrice Truman. Patrice is a national jury and trial consultant. She serves both plaintiff and defense attorneys all over the country. She is the founder of Truman Jury and Trial Consulting. Prior to her work as a jury trial consultant, Patrice worked for 2 civil litigation firms. She is a member of the California Bar. And before her work with as an attorney, she also worked in advertising in Chicago. So she gained a lot of knowledge in analyzing consumer research and accessing public sentiment. So Patrice brings a lot to the table when it comes to serving as a jury consultant. Adam Wilks is a deputy district attorney in Contra Costa since 2011. In his time as a deputy DA, Adam has prosecuted 79 cases to verdict, including cases of child sexual assault, domestic violence, attempted murder, and crimes of gun violence. He has also served as head of the DA office child abduction unit. So with that, we're going to turn over the presentation to Patrice to talk about jury selection, or Voidier.
Great, thank you. So in my first slide, I called it the intricacies of Voidier, just because there is so much that comes at you with Voidier. Is the slide up? Do I see that or no?
Pulling it up right now. Let's see. Should be up.
Got it. All right. You know, jurors tell me after they speak to the counsel post-verdict that it seemed so weird that here they weren't able to communicate with counsel during the trial. And they said, you know, it felt like they were actors and they came out of the TV and spoke to us afterwards. Because they do try to adhere, and of course the lawyers do too, not to communicate, not to really look at each other, you know, that type of thing. So they find it, they really look forward to afterwards when they can talk to you. Real quick, I just want to say what jury verdicts do when you stand back and think about it. It's helping, you're trying to find justice, you're keeping power in check with jury verdicts, and you're also moving democracy forward into tiny little steps. And I think jurors are realizing that more and more due to the political world and national events. So now the next slide, I want to talk to you about the three types of jurors in every jury box. You have the persuader. That person is pretty easy to spot. They are articulate, they're willing to raise their hand first in the oral voir dire. They are supervisors, managers at their jobs, or they have occupational goals. If it's a younger person, maybe in college, but has great career goals. That is a persuader. And don't think that just because somebody is maybe 26 years old, that they can't be a persuader. Because in my last two jury selections, and jury deliberations, these are actual, not mock. The foreperson has been somebody in their 20s who had a college degree. Then the next type of juror, back to persuader, there's about 3 or 4 in every jury box. Then the next type of juror is the participant, and that is the majority of the group, really, of the deliberation room. It's the person who, you know, is happy at their job, simply showing up, doing their work, going home, watching TV, having a beer, you know, going out with the girls. Not a lot of big career goals. They are cheerleaders to the persuader. And they're reliable. I mean, you have to take them seriously too. You've got to make sure you've got the right cheerleaders. And another example of that would be like the Safeway clerk or the, I just picked a jury last week in Sacramento, and I had one of my participants was an LVN at a hospital. So they're pretty easy to spot. Then you've got the non-participants. That's usually about one person in the box. If you have a very educated jury, which I did in Sacramento last week, it's amazing. I had about 7 BAs, 1 PhD, and then I got a young retail clerk at Macy's. She's probably going to be my non-participant because you could already tell that she was a little bit overwhelmed by it. They're okay. They're not dangerous. Never waste a strike on them. Then you've got that hidden juror. They're not common, but they are out there. And that is the stealth juror. And I have a colleague who just told me a month ago about his stealth juror who actually turned the entire case around and he lost. And what happened was, it's a med mal case, he was plaintiff. And this nurse filled out the questionnaire. He had a juror questionnaire. He said in oral Voidier, she said everything right. She had good answers. And she turned the whole group defense. And I said, well, Marcus, did you ever think that maybe in the end that she thought this could have been me being sued someday? So it was a little too close. He felt that she fooled him to get on that jury. It does happen. In the more famous cases, I think there was one on the Bill Cosby case. They'll be agreeable. They want to get on because they hope to write a book. That happened in some, I believe, even in O.J. Simpson. All right, next slide. The goal of Voidier, it's really to eliminate biased jurors. And what is really jury selection? It's not selection. You are deselecting. The court clerk sends you, or the jury commissioner sends you a group of jurors. Here's my jurors from Sacramento. They send you an entire group and you have to deselect and strategize from there who needs to go and who can stay, who won't be so dangerous. No jury will be perfect. And through the years, I've told myself, if I can leave a jury selection that I've assisted with and not feel sick or too worried about a juror that we kept on, then I can feel pretty good and hopeful and things will go well. So my goal when I help pick a jury is to help my client understand which ones are the poison apples, which ones are the Gumbies. I have my little nicknames for jurors, and which ones are the vanillas, and then which one might be a stealth. So a vanilla juror is a juror that I usually give a score of 3 to, out of a score of 1 being the worst, 5 being the best. If you end up with 3s, you're in good shape. That's a vanilla jury. You can teach them. Gumbies are the same. That's where you can mold them. They want to be taught and they're willing. There's an openness in their responses and in their juror questionnaire responses. So I have my little nicknames for people. And then you've got the poison apples. That's where you see a juror, the answers on the juror questionnaire are not good. There seems to be an attitude and clear bias. If there's a really clear bias, then you can get rid of them on a cause, which we'll talk about a little bit later. If not, they're just a poison apple because you know they're not going to go with you. That is who you will use your first strike on. If you've got people that you're not so sure about, hold off. The other side may get them off. That happened to us last week in Sacramento. There was somebody we weren't sure about. We were probably going to take her out in the 4th strike, hoping that the other side would get her out. They did. That was a great gift. Let's see. I am looking down at some notes just to make sure I tell you everything I wanted to tell you. All right.
I had a quick question.
Yes.
You mentioned you get the list from the court with all of the names, and you've done some advanced research about who cannot be on this jury. How much information do you get ahead of time of how a specific judge or department selects a jury in terms of the actual mechanics of calling jurors into the box?
Always. I always find out how.
And what are the, do you have a preference to how judges will call, juries from the veneer into the box? Some do 12 in the box, Some have a six-pack on top of that. What is your personal preference?
I love the six-pack, but honestly, it doesn't matter if you've got the juror questionnaire and you've got the random list, and the night before you've gone through the juror questionnaire. As long as I've got that random list, which is always given to you when you turn in the court's copy of the juror questionnaires. Now, if there is no juror questionnaire, then it's much tougher if it's just the 12. So usually judges are pretty open to the six-pack, and I've really not had a 12 in years. I mean, the six-pack is pretty common when there is no juror questionnaire and when there is a juror questionnaire. And in terms of doing research, when there is time, when you have the night before to go over the juror questionnaires, yes, I do get online and I do try to find out even more about a juror. So there's my little secret. Try to go online if you've got time, or call back to the mothership and have them, if you can start giving them names. I've seen it in the courtroom where a paralegal will take a photo and then send it to the mothership law firm, and they've got, you know, associates or whoever, paralegals, looking up names quickly online. It's hard, but it can be done. So next slide, the prospective juror questionnaire. I'm talking about this a lot because I cannot tell you how invaluable this document is. My one in Sacramento that I drafted was nearly 6 pages. That is how we were able to talk the judge into it. She's an excellent judge. This was her first jury trial. I absolutely love her. She's fair. She did her homework. She cared about making the right calls. And her name is, take this down, she's excellent for either side, Lori Damrell. Her father-in-law is a former federal judge. Her father is a federal judge. She just is stellar. Anyway, she allowed a juror questionnaire. The other side did not want it. He fought it tooth and nail. And she said, counsel, this is very fairly written, which is what I do with my juror questionnaires. I don't, if I'm working on plaintiff side, I work on in all playgrounds, plaintiff defense. If I'm working on plaintiff side, I try not to use too many words like, were you ever in a wreck? Was anybody injured in the wreck? I try to say, were you ever in a collision or an accident? If I was writing it for defense side, I would say, have you ever had an experience of automobile accident? But I try to put in the word experience. I try not to use those kind of overly descriptive words. Anyway, the judge said, Judge Demerol said, this is a very neutral questionnaire. In fact, counsel, we could say some questions are even good for you, because I always, when I'm working on defense side, I'll put in a question for plaintiff. It's not the key question, but I'll put a little something in so that they are more agreeable, so that we can get a questionnaire. The questions I try to make as open-ended as possible. And what we're trying to decipher is just their attitude, their biases, and I also want to see how they articulate themselves, even how they spell. Is their spelling good? Are they overly chatty? Overly chatty responses tend to be plaintiff jurors. The very concise, very cryptic almost responses, that very often is a defense juror. So I want to see that. I also ask questions that give me a little bit of insight about that person beyond the case issues. For instance, an invaluable question is, and I always put it at the end, describe yourself in 4 words. And you wouldn't believe how much, if we're in a close call situation, we always go back to that question. Did they say empathetic? If I'm picking for jurors, that's a word I want to say. Or if I'm picking for the defense side, do they say no nonsense, succinct? So it even in that, there's little hints. So you might consider using that question. It doesn't work so well for oral voir dire. And the reason being, for oral voir dire, if one person starts and says, honest, open, then pretty soon juror 4 and juror 6, and they're all kind of saying, well, honest. And so I'm not getting a fresh perspective. So that is a question I would consider using for a juror questionnaire. One that's great for oral voir dire is, what are 2 traits your parents taught you that as you have moved forward in your life, you have found to be invaluable? And that's a good oral voir dire question. So anyway, I've given you 2 of my greatest hits. All right. Let's see. Is there anything else I want to tell you about that? Yes. Okay. So what are the downsides of a juror questionnaire? Okay, here's the downside. You have to go, if you are the ones who presented it through me, because I wrote it, then you got to go and you have to Xerox many copies. And so you're at the Xerox machine. It's like back in law school when I was in law school, where we were Xeroxing a lot. And then you've got to get it to the court, usually by 6 p.m. at the latest, before everything's closed up, because the judge wants it the night before very often. And then you're up all night evaluating. And you can evaluate, if you're giving it a good job of evaluation, not just quick perusing, it takes you can get through about 10 an hour. So last week I had 50 to go through. I was up till midnight, but I was teaching my client also over dinner, and he kept probing and trying to understand. So anyway, that's a downside. You are up late the night before going through your questionnaire, unless you hire me and then I do it and I meet you for breakfast. Okay. And then I give you all my scores. All right. Next, the juror questionnaire. What am I asking in the juror questionnaire? You want to find out about the general demographics. You want to find out about their work experience. From there, you can tell the work experience, what type of thinker is this? Is this a black and white thinker, who tend to be the engineers and the architects and the, what else? What did I have last week? I had a lot of business degrees. Those are more of the black and white thinkers, as opposed to the gray area thinkers, which tend to be more, the artists and the actors and even the retail people, maybe participants. Those are the gray area. I'm going to move on because I think I need to hurry up a bit. Evaluating the juror questionnaire responses. Let me just tell you a couple of things about that. I always look at occupation. Very critical, because that tells you so much about a person, because they are going to bring their skill set from their occupation into the deliberation room. So all my business degrees that I kept on when I picked for defense last week in Sacramento, they are going to, be very logical and very, very succinct. They'll know how to talk to the participants because they boss them around in the corporation, whatever. So very much pay attention on the skill set that occupation has. That's why when I meet somebody, I always ask them, what do you do? And, oh yeah, tell me about it, because I absolutely use that when I'm helping deselect that jury. You also have to consider, what is going to be their basis of comparison when they are deliberating? For instance, in my mock trials, this has happened a lot. If it's like a car accident and somebody in my mock jury has been in a car accident, one juror I remember in Contra Costa came up to me And she said, Patrice, you know, this is about a car accident case. Well, I hurt my back 10 years ago and I didn't get any money. So there it is, your comparative. In a sexual harassment case, if you are on plaintiff's side, you don't want somebody who has been a rape victim, which by the way, in a sexual harassment case, argue hard for a juror questionnaire because you need to ask those very hard private questions. A rape victim in no way is going to give money to a plaintiff in a sexual harassment case who maybe had a few words said to her, or maybe years ago her fanny slapped or whatever, because the rape victim says, what I endured, I didn't get millions. So you've got to think about what is that juror's basis of comparison. And then you also need to look at what I'm calling hyper-individualism and societal changes. And that's coming out, you know, it came out heavily in the pandemic. That's the anti-vaxxers, the anti-government, the anti-mandate, the anti-regulators, the people who love their guns, the banning books movement. You've got to be very aware of what is going on politically around you or in that county. Counties in California are very, very different. You've got to do your research before you go into that county with a case. You've got to go online, see what those letters to the editors are saying, or whatever it would be now, online comments. You've got to just get a taste of what's going on. And let's see. Okay, we can move on. The next one, oral Voidier. It's great if you always make a promise of keeping it brief and then keep it brief. If you have the follow-up to a juror questionnaire, show them that you read it, and show them even that there's some notes at the bottom. Let them, they'll see maybe a little score up here. Let them see that you did stay up. You stayed up and you read what they wrote, because they put in about 25 to 30 minutes in writing that, answering those questionnaires. So ask those probing follow-up questions. If something is private and they put private, you'll go back into the judge's chambers and you'll probe there. And it's important with the inclusivity. Ask them, how many people agree with juror number one on that? How many people disagree? Don't show any inclination that you like the agreement or you like the disagreement. Be as neutral as possible, but see who agrees and who doesn't. And from there, you can even start understanding who will be the leaders in that group. Who is the one that will relate to your case the best? Get assurances from the group in oral Voidier. Can you all assure me that you will wait until you've heard all the evidence from the plaintiff's side? I am defense. I will be going second. I won't get a chance to talk to you again after the closing argument is given. Can you give that assurance to me? Can you listen to the judge and the with the jury instructions? So always get that assurance. It's a promise and they will give it to you and they will keep it. I mean, they've told me in post-trial interviews, we listened. Watch the body language. It may not always be the person speaking, it may be somebody behind, but watch the body language. Now with the pandemic, it wasn't that hard. And last week in Sacramento, we were still all wearing the mask. And you watch the eyebrows, you watch the forehead, you watch the shoulders. It's not that hard. I feel like I saw all of their faces, even though I didn't. So next slide, effective challenges for cause. The thing about a cause challenge, when you think about it, okay, peremptories, if it's just one defendant, one plaintiff, it's 6 on each side. I'm talking on the civil matters. I do mainly civil work. I do a little bit of criminal, but for a challenge for cause, it's great. It's endless. You can challenge as many people as you need to. or bring up that challenge, and hopefully the judge will go with it. But it is important to avoid those questions of, can you promise that you won't be biased, or avoid the word prejudiced, avoid the word, do you think you can be impartial? Because sometimes they won't, it's very hard for them to admit, yeah, no, bias and impartiality. Instead, ask this. If they express a belief on the questionnaire, you might ask them to quantify it. Okay, you told me this on a scale of 1 to 5, 1 being this and 5 being that. How would you quantify that? And please don't argue with a juror who's obviously bad for you. And here's why: it does eat up your time. Judges are putting more time constraints on oral voir dire, especially if you used a juror questionnaire. So it's really important. Don't think that you're going to teach the other jurors, because you're really not. Often they're not even paying attention when you're talking to somebody else, or by the time they deliberate, 3 weeks later, my Sacramento case is 3 weeks. And my client said, I'm going to try to teach the jury. I said, don't waste your time. They won't even pay attention 3 weeks later. They won't even remember. I'm going to move on quickly because I think I only have a couple more minutes. Peremptory challenges. I want you to, let's see, you will make your order of peremptories. I think we spoke about that. The most obvious one should be your first hit. The ones you're not so sure about, hold back. Like I said, the other side may do you a favor. I do want to mention that 231.7, addressing unconscious bias, it is in effect. It went into effect January 1st for the criminal cases. It's I think, tougher for me in my job, because if somebody I'm not feeling so good about in the criminal arena, this 231.7 went into effect for criminal. You really got to make a very good, Adam can probably talk to you about this, but a very good excuse why you're getting rid of that person. It kicks in January 1st, 2026 for civil cases. I just think I think it gives more importance to the juror questionnaire, that you can back up who you do need to get rid of, or you're not feeling good about, with some of the answers that you'll get in a juror questionnaire. Anyway, I'm going to move on because that law gives me the spooks. It just, because sometimes there's just a juror who we just don't like. That person just doesn't make us feel good. And it's hard to describe why. And I'm not saying it's because of their race or anything. It's just, there's just a feeling we have. And if we get them off, and we could have to say why, and you can't really say, well, I didn't just feel good about that person. So anyway, I'm going to move on. Let's see, peremptory challenges. So incorporating voir dire, this is my last slide. I think it's important that once you have your theme, you've got to start presenting that without planting seeds. You don't need to plant seeds, but start mentioning your theme in the voir dire, and definitely in your opening statement. And you can actually attain themes by what some jurors have written or said in oral voir dire. We got a great theme in the Sacramento case. Actually, it confirmed what we were going to say. And it's like, plaintiffs don't deserve a payday based on what happened to them. And payday was something that the jurors had mentioned in the mock trial, and then a juror mentioned it in a written questionnaire. And so that was then used yesterday in the opening. Analogies, definitely take from what you learn about a juror or jurors in what they do for a living. Use some of those analogies. Also, use it how they described themselves. you can develop analogies from their 4-word descriptions. So incorporate what you learn in Voidier in your opening, in your closing, in your theme development or theme expansion, and with analogies. And I have much more to say, but I cannot take any more time because it would be unfair. So I'm done for now.
Patrice, I just had a question.
Yes.
When you've been unable to eliminate someone with cause, do you put a special emphasis on distinguishing between the persuaders versus participants in terms of like who's the most dangerous to keep on that jury?
Absolutely, absolutely. You use your strikes on the persuaders who you see as dangerous, but there are a couple of, I mean, we did use we went all 6 because we knew who was coming up. We knew that we had some great scores coming in. So we did get rid of 2 participants, but you know, because it's like they could say just even one sentence that could make everybody think and change some minds. So yes, always give emphasis to the persuaders. And again, they are fairly easy to spot. Understand their profession too. Really do research on it. If you're not sure what a profession does, do research on it so that, you know, the night before, so that you can spot that persuader and how that person could add or detract from your argument, your evidence.
Yeah, and I think there's likely a key difference between criminal and civil. In the civil world, at least in state court, it's a 9-3 calculus. So 9-3, you win either direction. In Adam's world, you got to have a unanimous jury. Adam, do you feel like when you have a participant you haven't been able to get off, that you don't worry too much about them because they're likely to go kind of with the flow? How do you handle those juries?
So I think to Patrice's earlier point, you know, that's where I'm looking at my questionnaires and I'm looking at what's coming next in terms of the jury panel and the selection that I'm going to be choosing from for the next jurors I have available. So I use different language. I think of leaders and followers in terms of persuader. You know, it's a similar concept. But if I have somebody who has, you know, whether or not they are sympathetic or more likely to be on board with my sort of theory of the case as I'm presenting it, if maybe they're going to be a little bit less sympathetic or more neutral towards my case thematically, but I also look at that person as more likely to be a follower, then yeah, if, you know, chips are down, I'm probably not going to burn a kick on that person.
Yes, it's like very much picking in federal court too. I mean, your whole thought process is, wow, can those 2 persuaders bring in everybody? For instance, in federal court, about a year, well, this last summer, you know, because COVID closed stuff down for a while. Last summer, there was a kindergarten teacher, okay, not dangerous. Even though she is educated, think about it, guys. She talks to 5-year-olds, and you could already tell just being in that federal courthouse, in that courtroom, that she was already a little bit intimidated because, you know, all day she's talking to 5- and 6-year-olds. And I don't mean that in a condescending way, but that's her world. Sure, she'll talk to parents, but even then, a lot of it's done by email anymore. So did we burn a strike on her? No, and she turned out she was fine. She went right with our persuader. So there was nothing dangerous.
Well, I think now's a good time to kind of move on to the next phase of trials. So you have now picked your jury. They've been sworn in. They have received their preliminary instructions. As many of you know, the next the first thing that happens is the attorneys give opening statements. And I'm briefly going to cover that topic. So opening statements, let's see, am I screen sharing? I don't think I am yet. Just iron out some technical issues here. Thumbs up, you can see it? Okay. So why is it important? It's fairly self-evident, but it's very important for several reasons. The first is it's your first opportunity for persuasion. The jury is really kind of a unmolded piece of clay, and they want to hear why they're here. They're very eager to hear why they've been brought here. And that they've had to volunteer their time to hear this case, whether it's civil or criminal. And it's your opportunity to prepare the jury's minds for how to receive the various evidence, and also to kind of start preparing them on how to, what sort of conclusion they should potentially draw from that evidence, without arguing the case, of course. It's your first opportunity to establish credibility. I would actually back off this. I would say your first opportunity to establish credibility is during the section that Patrice covered, during Voidier. There is a lot of rapport that's created during the Voidier process because it's a little free form. It's a real opportunity to kind of let your personality shine, to kind of make light of what someone said without, humiliating, never wanting to demean anyone, but just for you to bring some lightness to the process. So I think there's already been some rapport, but the opening statement is really an opportunity for the jury. What they're looking for is a credible guide for this trial. And if you are prepared, and if you speak clearly, and you don't speak down to the jury, you're going to establish yourself as a figure that they can trust in this process. The other reason that opening statement is so important is the jury is kind of at peak attentiveness. As I said before, they're very eager to learn what this entire case is about. You have their undivided attention. They haven't been, grinded down by multiple days of evidence and witnesses and exhibits. So they're really kind of laser focused in on you. There's definitely studies out there that show just how important opening statement is. Some have shown that 80% of jury verdicts conform to their initial impressions. So that's pretty, kind of persuasive, or that's pretty kind of important to really kind of persuade and be credible for that jury in this process. General considerations relating to opening statements. There's an unqualified right to give an opening statement. Some judges can be a little kind of restrictive in the amount of voir dire you can conduct, as Patrice had kind of alluded to. Some judges, in fact, have not allowed jury questionnaires or limit the time. Opening statement is much more kind of established by code. You have an unqualified right to give an opening statement. In terms of time limits, this is something that you should be aware of. Some courts will give time parameters around it. It's not the typical thing, but it is definitely possible. There's also courts, particularly in federal court, where you'll have a time limit for your entire case in chief, including opening statement. So you want to be aware of any time limits that are placed on your case, and basically to plan accordingly. You wouldn't want to have, 7 total hours of trial time and devote a full hour to opening statement. So you want to definitely get advanced information on the judge's standing orders. I would also, encourage you to reach out to attorneys that have tried cases in that department with that judge. That would also hold to kind of the full trial procedures of that judge, including voir dire. And I'll touch a little bit more on this. It's likely in your best interest to keep it brief. You don't want to drone on and kind of bore the jury at your opening statement. It is really a time to engage the jury, establish that credibility, give them that roadmap of what this case is about and how the pieces are going to fit, but don't waste too much time with it. Unlike closing, there's no plaintiff or prosecution rebuttal. However, if one side were to move for a non-suit, which is on the defense side, the court may permit a reopening. This isn't very, this is actually really uncommon. A non-suit after an opening statement basically means that an attorney, for example, a plaintiff's attorney, on its face, the opening statement was legally deficient, meaning they forgot to mention that their client suffered any damages. So they haven't met their burden of, the basic tort, the elements of their case, that there was harm incurred. If there was a non-suit because, that you forgot to mention something, a court almost always is going to permit you leave to reopen your opening and mention whatever you forgot. Once again, it's not something that typically would happen in a trial, and almost all of opening statements are going to be sufficient at least to survive a non-suit. Opening statements are also not a limit on evidence to be introduced. So if you don't cover something in your opening statement, for example, witnesses or some key issue in your case, you're not going to be precluded from bringing in evidence on that issue if you didn't discuss it in your opening. So it definitely is helpful to be as encompassing as possible and give the jury a nice kind of, once again, a roadmap for what the evidence will be. It's not going to limit you. General strategies for an opening statement. Like everything, including voir dire and closing, this is a highly personal thing. There's not a one size fits all approach, but there's definitely some general parameters that practitioners have found lead to the most effective openings. As Patrice mentioned during voir dire, you want to have a case theme. This is something that you should have established during litigation, and it should have been guiding your discovery. It should be guiding the questions you would ask in a deposition, in a civil case at least. And it should be really kind of straightforward and kind of, if you were to boil down the case, what is the case theme? What's going to grab a jury? What is this case ultimately about? In my world of civil litigation, personal injury, wrongful death cases, things that could be a case theme could be the violation of a safety rule that was developed to protect the public. It could be corporate greed. It could be the defendant thought the rules did not apply to them or that they were above the law. Profits over safety. That's always a strong one in like a products liability case. Or maybe selfishness over safety. If you had a defendant that was text messaging, that could be this defendant was so self-absorbed that their personal need to reply to their friend, to send, to comment on that TikTok, whatever it was, that was more important to them than the life of my client. Those sorts of things are going to be really effective themes that you should be hitting and guiding your opening statement. You shouldn't throw a bunch of facts and evidence. It shouldn't be a laundry list. These are the witnesses I'm going to be calling, and here are the things that they are going to say. that's not gonna resonate with the jury. They don't know what this case is about. They don't know, you've been living and breathing this case for months. So you know it and you feel like you can talk in this shorthand and they'll understand it. They don't know anything about this case. Tell a story. And stories are often told best chronologically. It doesn't have to be that way, but it's definitely the most straightforward way. I know like directors in Hollywood, like Quentin Tarantino, like to jump back and forth in time. Maybe not the best strategy for an opening statement. You should introduce some of the key players and how they advance the story and case themes. You don't have to hit on every witness, but definitely the important players in your case. You should discuss what they're going to be saying in evidence. It's always a good idea to address bad facts that you expect the other side to bring up in their opening. It really is helpful to kind of de-escalate, to take the wind out of those sails. It's also helpful to gain credibility. If you're just, putting your best foot forward and not addressing any bad facts, and then your opponent gets up and gives an opening and talks about, there's a key thing that, opposing counsel didn't bring, and here it is, they're gonna have already won that credibility war. So addressing some bad facts, but do it in the middle of your opening. You don't want to have that be kind of the anchor leg of your opening statement. It's best to grab the jury with a positive opening, address some bad facts, and then close strongly with a positive message. This is just a basic outline on a personal injury opening statement. David Ball on he's a prominent figure in the tort world. He has a book, David Ball on Damages. This is just one of his kind of suggestions. Talk about what safety rule was violated, how it was violated, why you're suing, address defense contentions. That's the bad facts that I already mentioned. Talk about causation and damages, and kind of dovetailing with the damages, talking about your client before the incident. What was your client like before they suffered this catastrophic injury or whatever calamity befell them? And then what can they do about it? That's where you're empowering the jury already they have a way to make this right, at least in this civil realm or in this criminal trial. I'm just going to briefly go over some improper opening statement conduct. Mentioning matters previously ruled as inadmissible. These could be things that were ruled as inadmissible by in limine motions or things that are standing inadmissible evidence. Some examples of that would be things like the corporate wealth of a defendant, the presence of insurance, the immigration status of a party. All of that is inadmissible by code, and it would be potentially, if you're willfully violating it, punishable as contempt of court and even suffering terminating sanctions, meaning if you were flagrantly violating this, you could lose the case for your client in the most extreme cases. You shouldn't discuss matters without a good faith belief that these issues are going to be supported. And that's actually in the professional rules of conduct or the rules of professional conduct. You can't state matters of personal belief. If you're saying I, that's probably a good indicator to you that you're veering off the course. You shouldn't be talking about in the first person, really. And so if you're saying, I personally looked at this evidence, and in all my years, I haven't seen a case this compelling, that may be getting into, or that likely is violating this rule. You're not allowed to argue the case. This one is definitely a fuzzy line. Attorneys love to kind of, get their toes as close to this line and maybe dip a toe over and see if anyone shouts. But basically, the guideline is you're supposed to be stating what's going to be brought into evidence, but it's not until closing argument that you're to argue how that evidence is to be received by the jury, or the most reasonable interpretation of that evidence. That would be the province of argument, and it's just not the place for opening statement. Also, there's a lot of research that finds that if you argue prematurely, you're going to lose credibility with the jury, because they don't know these facts. They haven't heard it from witnesses yet. So they're not necessarily going to believe you, or they're going to find you not credible if you're going too far into the realm of argument. You're not supposed to discuss applicable law. However, if there are statutes or other guideposts that are really the crux of your case, you could request the court pre-instruct on those, or you can request leave of court to discuss the law with during opening statement, but you would need leave of court. Responding to improper conduct, you want to, in the most flagrant examples, you would want to object timely and request for jury admonishment. Otherwise, the objection is waived. But strategically, especially in cases where the improper conduct is you believe that your opponent has argued things that are not going to be supported by evidence, first of all, that objection is not likely to be sustained because the judge doesn't necessarily know what is going to be brought into evidence yet. But it is much more effective to give your opponent as much rope as they need to tie that noose, and then to really hang them during the closing argument, because they have essentially made promises that they won't be able to keep. They've said the evidence is going to show this, and then at the end of the case during your closing, you're going to remind the jury of that broken promise. It's going to be way more effective than objecting during their opening statement. And then real briefly, dues of opening statement: use simple language, use eye contact, but don't stare down a juror. Don't, look deep in their eyes and make them uncomfortable. Just, normal conversational eye contact. Use an engaging attention-getting opener. I talked about bad facts. Being brief, I don't think there is a hard and fast rule, but I think 30 minutes or so in a straightforward personal injury case is appropriate. Using some visuals is helpful, but I would not go into real text-heavy visuals because they're not going to pay attention to you. They're just going to be reading your slides. You should be practicing with lawyers and non-lawyers. Oh, I should have mentioned, with regards to visuals, everything needs to, you need leave of court or stipulations as to showing anything to the jury during opening. So you do not want to get caught unprepared for that, where a opposing counsel's objecting because you haven't received agreement on what you're going to be showing the jury. You have to take care of that pre-trial. The last thing is be yourself. Juries can smell inauthenticity, so don't watch a bunch of Hollywood movies and try to get into the character of whoever you would like to be. You got to be yourself. You can put on a persuasive hat, but definitely don't try to be overly dramatic or maudlin. Otherwise, they'll know that you're kind of faking it, and it won't be well received. The don'ts are mostly the kind of mirror images of those do's. The only thing I would say that I haven't really touched on is you don't have to say the evidence will show every time you speak during an opening. It's enough to say the following is what the evidence will show in this case, and then just talk. It's really stilting if you're saying the evidence will show this, and then you say one thing, the evidence will show that. You don't have to say it each time. Just say it once at the beginning. So with that, I'm going to turn it over to Adam to talk about closing argument.
Fantastic. And then I'm just getting set up here, and I see that we are at 3:30. So in terms of time, I'm expecting about 15 minutes. Okay.
Adam, you can go a full 20 if you'd like.
Fantastic. Thank you. I am going to put on my screen share mode, if that's all right. Hopefully everybody can see this.
Adam, it's a little difficult to hear you. If you could speak up or turn your volume up.
Oh, perfect. All right. How about now? A little bit better?
A little bit better.
Okay. Sorry about that. All right. I'll keep my voice up. So my name's Adam Wilks, again, Deputy District Attorney, Contra Costa County. I'm here to talk to you about closing argument today. And so big points for today in terms of teaching points. I want everybody to understand structure, tactics, and a little bit by way of example of the difference in closing argument of arguing versus merely reciting the facts that the jury has already heard. And I highlight that because that latter point is really what separates experienced trial practitioners from people who are probably more green. So as we start off shifting gears and talking about the structure of a closing argument, I like to use this example. So, here's 3 books that I liked. And I use the rhetorical question, well, which one was written correctly? The question is itself ridiculous. And I think that kind of points out what I'm getting at, which is there's no one right way to give a closing argument. There's no necessary correct argument to make or like the 100% solution for every set of facts that you're going to come across. What instead we can do is build our structure in a way that lends itself to a clear understanding by our jurors and a persuasive presentation. So when we start off, let's talk first about the things that are fair comment, and that being anything that is the plain language or plain sort of meaning of the jury instructions, and anything that the jurors can consider as evidence. Impermissible comment, that'd be vouching. And I think that's what Nick was talking about earlier when he said, when you inject yourself, here's what I think. It is, 1, patently objectionable. And it's an objection that judges can see a million miles away. They will sustain that objection. And that dings your credibility as an advocate, because at that point, the jurors are really mindful of who got objected to, who gave a more professional presentation. And that's an easy thing to sort of scrub out of your vocabulary. Facts not in evidence, evidence stricken. Facts of other cases. Here's another case where a jury did this. So if the jury in this other case reached the following verdict, how could we conclude, how could we find in favor of the plaintiff based upon this set of facts? It's impermissible. Same thing, efforts to settle, insurance, collateral source, or financial status of any of the parties. So when we prepare for our closing, one of the things that I put up every time, we do not rise to the level of our expectations, we fall to the level of our preparation. So advice that I would give to all of you is in every closing argument that I want to give, ideally, I have said every word out loud to another person who was not a lawyer. I used my wife as my sort of ideal sounding board every time. One thing that I also recommend to people, it's painful in the way that exercise is painful. You have an iPhone, you have a smartphone, it has a camera on it, record yourself because you're not going to like it. And that's how valuable it is as a teaching tool. The tells that you have, the verbal tics that we hang on to that everyone has. We can iron those things out by rehearsing, by practicing our closing arguments. I advise you to do the same. Now, sometimes this happens, and when I give this training for new misdemeanor attorneys who are becoming prosecutors, I also say, hey, here's your worst case scenario, which is, look, you have to know your facts forward and backward, and then you need to know how you're going to start off the first words out of your mouth for closing, and you need to know how you're going to dismount and then have an idea of rebuttal. Now, when we talk about moving on to structure, I'd like to say that nothing that I'm giving you is my own sort of product. I'm taking everything that I learned about structure from this book, and I would say worth its weight in gold. I have used this book, I'll say now, for the last 7 years. Winning Jury Trials, Trial Tactics and Sponsorship Strategies by Klonoff and Colby. It contains the following outline. When I am writing a closing argument in any set of facts, in any case that I'm handling, this is the first thing that goes into a Word document for me as I begin to write my closing. So this structure that begins with opening remarks. So opening remarks, the first words out of our mouth to the jury. Well, so what is that? Do we start off by thanking our jurors? Do we start off by saying, well, hey, I'd like to tell you that jury service is very important. I'd like to tell you that a closing argument right now, this is a little bit like putting together the pieces of a puzzle, right? We've all heard people do that. Klonoff and Colby had, I think, pretty strident language about it. In our view, this presentation serves no useful purpose. They use the language, a lost opportunity, actually damaging the advocate's case. This is echoed in trainings that I have attended from experienced SAU prosecutors in California. You do not begin by thanking your jurors. So what do you do instead? I like to start off in the criminal context. And I think this can translate to civil, which is it's either going to take one of three forms for me. Either I begin by talking about who the victim is or was. Start off and say, I mean, Jane Doe is 26 years old. She has 2 children. She works 2 jobs. Nobody deserves this. And then putting up a picture of perhaps injuries she sustained or a reference to the facts as we now understand them to be. I also then use lines like, everybody deserves to be safe, or the law applies to everyone. What I am looking for in those first words is a reason to convict that the defense cannot attack. I want to start off with a principle that is irrefutably true. So when I start off by talking about my victim by way of biography, what I am doing is in humanizing them, I am talking about the reason why we have the law in question. So then from there we shift, we go to our brief summary of the case. And the idea is something like, look, what happened here, and I use the kind of pattern language. This isn't some great mystery, right? What happened here is obvious. And I want to summarize my set of facts, and I'd like to do it in a way that is persuasive, accurate, and passionate, that I can sum up perhaps in about 30 seconds. You know, in the classic example of DUI, look, we know what happened here. The defendant got into a loud argument, loud enough that people called the police. The defendant then got into his car because he was emotionally charged up after a night of heavy drinking, got into his car, and he wrecked his car. And then he was standing outside and trying to blame somebody else because he didn't have the responsibility or the tools to accept his own behavior. That's what's going on here, right? 30 seconds, and it explains everything about what we're doing here. Shifting gears. Once I give that sort of statement, once I give that 30-second elevator pitch or postage stamp sized version of the case, I then want to talk about concessions. And I quickly transition in talking about concessions. I talk about the things that the defense would frame as important, and I tackle those early. And I use the line for people, look, you want to treat those concessions or identifying those bad facts, the way lawyers sometimes talk about bad facts, reframe those as strengths. You talk about them the way you would in a job interview. So in the context of domestic violence, well, we have no third-party witnesses, right? It's not like this crime happened where we have the incident on camera. It's not as though she grabbed her phone and started recording the defendant as he was physically assaulting her. Well, I mean, here's an example, and I'm putting it up, of actual language that I've used in a case. You know, he assaulted this woman in a private place where she had an expectation of a degree of safety. Other examples, well, you know, DUI where defendant passed out at the driver's seat, 2 kids in the back seat. Okay, yeah, this DUI, I get it. This doesn't end in a collision. It just ends with a very different kind of tragedy. You know, language of that type. And so once I've sort of talked about or identified identified those points or those bad facts that the defense would say are important, I want to shift gears, and I now want to talk about or highlight strong prosecution evidence. This is where we are going to talk not only about the evidence that is sort of our most persuasive evidence, we're also going to talk about the complete jury instructions, highlighting those jury instructions that favor our side or favor our presentation of evidence. So if you're going to be mentioning your burden of proof, and I'll talk about this in a little bit, this is kind of the space where you want to do it. Prosecutors sometimes use this slide or a slide similar to it of considering what's only inside the circle, not considering those things outside of the circle. I also am a big fan of a presentation in which I put up, I know that there are different jury instructions for civil, but we call them the CalCrims as prosecutors, the elements of the offense that you have to put up. Now, I know that there's the rule, and we talk about this over and over. You don't want to be too wordy in your visuals. You don't want to be too, you don't want to have too much text on a PowerPoint. But the flip side is that your jurors are going back there with a stack of jury instructions. You want to arm them by being able to identify the instructions that are important and then translating those things into plain English. So with something like this instruction, CalCrim 875 for domestic abuse. Well, so here's the way that that looks. I would then put up, well, what's a definition of willfully? All right, versus what's a definition of a traumatic condition? I use Times New Roman language to show that I'm directly quoting a jury instruction versus assault with a deadly weapon. This is how the instructions actually look. And if you look at it, I kind of turn to the jury and I say, look, this looks like Latin to me. When you read these words, they read like stereo instructions. So I don't know, I'm going to kind of shift gears from here. And then I want to use plain language where I can. And at that point, I shift the jury instructions into a font that distinguishes my argument from what's actually in the jury instructions. And then I explain to the jury a common sense meaning of the law. Meaning I actually explain, well, in plain English, here's what each element of the instructions mean. And then from there, as I talk about my jury instructions, I talk through one at a time. Well, did the defendant do this on purpose or not? And then I go through each of my facts that would prove that, each of the arguments that I could muster from what they heard from witnesses. And then I go through, and in a presentation a lot like this, I'll just go through element by element, just like you're seeing me do right now. And this isn't hard to do. It's just a matter of taking the same PowerPoint slide and then just graying out some of the text and going through one to the next. I find that to be very helpful. I've had jurors echo that for me, that was made it really clear. It's also helpful in a case where you have to prove the case beyond a reasonable doubt. Now, once I've gone through and I've identified to my jurors those jury instructions that are helpful to my side, the reasons why I've proven my case, I then want to shift gears and I want to talk about exactly how strong my case is without vouching. And the way that I do that, when I was a kid, there was a guy on TV whose name was Ron Popeil. And he used to sell this thing called the Showtime Rotisserie Grill. And he would start off every time and he'd make you the pitch. He'd show you why the Showtime Rotisserie Grill was great. And then he'd say, and I'm not going to sell it to you for $300. And I was like 12 years old and I had no idea how much $300 is, but I was like, man, it seems like it's worth $300. I'm not going to sell it to you for $280. I'm not going to sell it to you for $240, not for $200. I'm not going to sell it to you for $180. And the whole time, you realize what he's doing. That's I think it's called the countdown, and it comes from like old vaudeville or carnival pitchmen. They used to do this. It's like an old sales tactic. I do something very similar, which is I say, I want to get really real with you folks about exactly the quality and quantity of evidence in this case. So to use kind of the easiest example of a DUI, once I've talked about my case, I'll say, look, I want to level with you. I want you to imagine that you heard the exact same case as you just were here for. But I want you all to imagine that the officer who was the arresting officer you heard from, it wasn't Officer Nelson, it was Officer Green, and it was his first day on the job. I'm still standing right here. This trial is still happening and the defendant is still guilty. Or I'd like you to imagine that instead of a BAC twice the legal limit, I want everybody to imagine that the BAC that you heard from the GCMS, the gas chromatography, was 0.09 or 0.08. Imagine that we didn't have the defendant slumped over behind the driver's seat on body cam. Or I'd like everybody to imagine that we had no blood test at all. I'm still standing here and the defendant is still guilty, and here's why. And for each of those points, I'll highlight the reasons why. Regardless, you could I've still proven my case. The idea being you kick out as many different legs of the stool as you can. And in presenting the case to the jury in that way, you kind of show them, oh, wow, the prosecutor or this side, I had a lot of evidence. And based upon that, I now want to shift gears and I engage in what is called binding and attacking defense evidence. So I'm comparing the strength and force of my evidence by talking about how, look, you can believe 3/4 of my evidence and you still find in my favor. But the defense needed you to believe each and every thing that they told you. And they needed you to believe all of those things together. So I'll usually begin by referencing, well, of course, the defense against this strength of evidence, they had to present a defense case. They had to say something. And I'll start off when we attack defense witnesses, I like to play a game called, well, what did you expect? And what did you actually get? So this is where when you start to think about jurors, you think about what they think from Law and Order, from television, from the perceptions that they probably have of the way courtrooms are supposed to work. I use this pattern example, and this actually, I believe a substantially similar example comes from Klonoff. And our expert says, hey, there was a collision at 72 miles an hour at the time when the defendant struck the victim. You know, it's a gross vehicular manslaughter while intoxicated. Maybe it's a Watson murder. So imagine the defense brings in an expert that says, well, that car could have been traveling anywhere from 40 to 80 miles an hour. That actually happens. That happens all the time where you see the defense just trying to kind of widen the goalposts. Well, what would we say in response? Well, look, if the defendant were actually not guilty, wouldn't you kind of expect that they could have brought in a witness who could say, you know, this highly paid, highly credentialed defense witness would have been able to say, you know what, the prosecution's witness has it all wrong, and there's no way that the prosecution's theory is correct. Wouldn't you also expect them to say, there's absolutely no way that their client was driving 72 miles an hour? Or another example, the defense calls a witness who was on scene, actually on viewed the crime, and yet strangely is nowhere inside the police reports. Somebody who's never given a statement about what happened, and then they show up right on the eve of trial, and suddenly they saw the whole thing. Well, boy, you'd want to hear from somebody who came forward immediately, who was credible from the start, who volunteered their version of events early on because they had something important that they wanted people to know about this case. This is where we also attack bias or what their connection is to an involved party. In sum, I try to advise people when I'm teaching closing arguments, compile a list of every reason you can attack the defense or a piece of defense evidence. And the reason for that is because if you do not do so yourself, you cannot count on your jurors to go back there and invent those reasons for you. That does not happen. When you can tie each and every attack on a defense witness or a defense piece of evidence to the actual pattern instructions. Here I'm taking from CACI 107, that's like you're in civil, it's the civil witness instructions. It looks like this, right? It's got a big laundry list. I like to put up something like that. Now, you don't want to overwhelm your jurors with too much text, but you say, look, you're going to see this big list of factors for what you need to consider. Here's one that I would point you towards. What was this person's relationship to either the set of facts or the person who was involved to something that they saw that was important? Highlight whether or not they've made inconsistent statements in the past, and then talk about those and what those actually mean about a person's credibility, showing the jury the parts of the instructions that relate to your case. And again, pointing out to them that, just like with your witnesses, that the defense can't put on witnesses that are not believable or not credible and then expect that those people are entitled to some sort of weight. In some, you frame all defense witnesses as their star witness where you can, and then you talk about their shortcomings. Now, I only have a couple of minutes. I realize I'm right at 20 minutes, so I just want to take a moment and talk about burdens, because it's obviously very important in criminal. For civil, you have different rules where in most cases you're going to be bound and not given the opportunity to do a rebuttal. So to the degree that you do, I would say keep it limited and tie it to the actual instructions that you have. If you are given the opportunity for a rebuttal, I would avoid talking about your burden of proof until your rebuttal. But again, in civil, talk about it towards the end once you've talked about the defense evidence or the opposing side's evidence. So how do we stick the dismount? Well, I would usually say, look, I don't know what he's going to say, but if I were doing his job, here's what I'd tell you. And then I'd highlight all those reasons. But at the end of the day, then you talk about the burden of proof in the case. And then on behalf of the person who you are representing, on behalf of their interest, that's when I will extend a thank you. So usually at the end of in my case, at the end of my rebuttal, that's where I'll say on behalf of Jane Doe, on behalf of this person, I want to say thank you. And in criminal cases, I'll say, and I want to say thank you to you from the bottom of my heart, depending on if that's a case where that's appropriate. And then ending on your request, which is, some people talk about as an advocate, well, you leave it to the jury. No, make it very clear what the appropriate request is based upon the argument that you have presented. So I use mine, defendant is guilty, this case is yours. So with that, I'm going to end here in the interest of time. And I want to say thank you to everybody for giving me the opportunity to present. And I'll stop screen sharing. All right, thank you. Sorry for running over. I apologize.
No, you're fine.
All right,
and you thanked at the end, just like closing. That's good.
See? All right.
I really love the Ron Popeil analogy. I think it's something that I have kind of unknowingly used at times in trial. Actually, at times with burden of proof. Because in civil, we have a preponderance standard, which is, as you know, lesser than the reasonable doubt standard. So it's, you sell it, even if our burden of proof was a reasonable, beyond a reasonable doubt, we would have met that standard. And then kind of laying out why we have met that standard, but that's not our burden of proof. And then you talk about preponderance and how it's, just the weight of the feather on one side of the scale, we've met our burden. So it's kind of something you can use in all sorts of ways. We don't have any questions in the chat. If anyone does have any questions, feel free to pipe in now. Oh, thank you.
I noticed somebody asked about the name of the book. If you jump on Amazon, it's like $60, but it is the best $60 you're ever going to spend.
Appreciate that.
So if no one else has a question, I had a question for Patrice. You referenced this rating scale, the 1 to 5, and I forget what's good and what's bad, and 3 is neutral. What are the factors that go into the score you give a juror?
What goes into it is the responses they gave me, how well, like for instance, here's one, and he's a 3-. And this was a defamation case. He is a service rep at a credit union. He's single, no children, BA Humanities. So far, there's nothing scary. He said, difficult to explain about, we asked, how are you a judge of someone's character? And he said, difficult to explain, but based on an intuitive sense, so he's a deep thinker, about how they think about things. And if I sense malice, and I liked that answer because our defendant really had nothing to do with the alleged defamation. So we liked that. And then he said something, about, does a person's reputation have monetary value? And he said, certain people will avoid people or business that have a bad reputation, thereby having monetary impact. But quantifying a reputation value seems difficult or impossible. Meaning, we took that as him saying, look, I'm not going to give millions for a supposed loss of reputation. So I gave him a 3-, which is a good, he's a good juror. A 5 is very rare. A 4 is pretty rare. Most people are going to be a 3. They give me answers that I feel we can work with, we can teach. A 2+ is the very lowest that we'll accept, and pretty reliably, because I go back and I studied then what scores I gave and how it worked out. I actually have a very good hit record. I wear the same dress to jury selections. My client in Sacramento said, "You're really superstitious." But so I go back and I check my scores, and anybody a 2 or below really is bad and proves to be bad in the deliberation room. So it's just the sense you get, and whether that occupation seems to meld with your case facts, and it's kind of hard to explain, but it's just, you'll know once you get used to the system, once you learn how to really score somebody.
Well, we're at 6 o'clock, or just, no, we're at 6, and I don't see any questions in the chat. So with that, Anne, do you have any closing remarks to make?
I don't, except that was amazing. That was really a lot of great information packed into. We could have probably gone on for a little bit more, I think, but that was great. Thank you all very much. And again, I want to thank our sponsor, iPro, who does trial director, who we'll hear from in June, I think. And I look forward to seeing all of you next month. And thank you all.
All right. Well,
Thank you.
everyone.
Good night, everybody.
Good night.
All right,
All
bye,
right.
everyone.